Hi, welcome to our channel with Capital Financial Planners. My name is Amanda Pliska, and in this video, we're going to highlight a key consideration when planning your legacy that usually gets skipped or not even thought about, and that is your digital footprint. This topic actually came from one of our clients who wanted to know the easiest way to transfer their Marriott points. And it got us thinking about those type of assets we often overlook. The ones that, you don't necessarily or typically assign beneficiaries to or know how to transfer. Because in today's age, our lives are increasingly online, but many individuals overlook this one critical piece of planning for the future, digital estate planning. And without a plan, these accounts may become, inaccessible, lost, or even vulnerable after you're gone. So let's dig in and discuss the differences in traditional estate planning and the additional considerations that are needed with digital estate planning. And the funny thing is, here's the challenge. Studies show that almost 80% of individuals are concerned about their digital assets, yet nearly half admit that they've never, even heard of digital estate planning. And with the average person managing, and it's crazy to think about, up to 100 different online accounts, it's easy to see how families can struggle to gain access, after a loved one passes away there. And let's take a look at the differences, between traditional and digital estate planning. Traditional focuses on documents, so think wills, titles, account records. They can be kept in, safely in filing cabinets, safes, and can be physically seen and touched. These physical records are simple, they're governed by long-standing inheritance laws and, have clear instructions with essentially no tech barriers. But today, many of those same records live online. And unlike a paper file, these digital accounts are protected by layers of passwords, security questions, privacy rules. Errors can't just open a folder in a safe like they could with traditional assets. Accessing digital assets is a whole new challenge, one that requires a different kind of planning. And, families and fiduciaries often face four major obstacles when trying to access digital assets. First, strong passwords and two-factor authentication can lock them out. More and more online accounts now require a second confirmation from another account. So if an error doesn't have that full picture or legacy credentials, access can be nearly impossible nowadays. Second, advanced encryption protects data by making it unreadable without the correct codes. For example, even if someone finds a deceased loved one's laptop, the files may be completely inaccessible without the encryption key. Third, criminal laws prohibit unauthorized access, even for spouses or children. For instance, logging into a deceased person's email without proper authority can be considered illegal. And fourth, strict privacy regulations prevent service providers from releasing account information without proper consent. So, if any of these challenges, faced become reality, accounts become locked. And that could mean, delayed benefits for survivors. And without planning, surviving spouses could, face delays in accessing funds, retirement accounts, or health benefit information. And, those things aren't just sentimental losses. They're critical financial resources your family may need immediately. So to address some of these challenges, the revised Uniform Fiduciary Access to Digital Access Act, which is a mouthful, or the RUFADAA, which is still a little bit of a mouthful there, was introduced. And as of 2025, about 47 states have adopted it. This law creates a hierarchy for digital assets, first through online tools like for instance, Google has an inactive account manager. Second, through provisions in your will, trust, or power of attorney. And then third, through a court order if no other authorization exists. So even with these laws in place, provider policies, still matter and, often will take precedence. Terms of service agreements can actually override traditional estate laws. So that means your family might not be able to take ownership of your accounts unless you've used that provider's online tools. So, this step is crucial if preserving your digital estate, digital assets is important to you and your legacy. So think of it like naming a beneficiary on a retirement account. Those online designations typically supersede what's written in a will or trust. So, platforms like Facebook, allow a legacy contact, while Google lets you set up an inactive account manager. But if you don't take action, important memories, photos, or even financial details could be lost forever. So, how can you protect your digital legacy? Here is seven practical steps, every individual consider. So first, define the scope. Identify all digital assets from federal benefit accounts and retirement systems to emails, photos, personal financial platforms. Second, create a digital inventory. List those accounts, usernames, and where passwords are securely stored. Include instructions for what should happen to each account after your passing. Third, appoint a digital executor, someone who is, a little bit more tech savvy, right? Uh, to carry out your wishes, like closing the accounts, transferring the data, or even memorializing social profiles. Fourth, update legal documents to authorize fiduciary access to digital assets, in compliance to that act, the RUFADD Act there. Fifth, use a platform tools like Google's Inactive Account Manager, that Facebook legacy contact. Apple also has a legacy contact, to align with the wishes, steps 2 through 4 there. Six, secure your inventory an encrypted password manager. There's like a digital vault. You can also use your attorney as well. And just make sure your executor can access it as well. And seventh, just keep your plan updated. Review annually for new accounts that you opened, password changes, and updates to laws and platform policies there. So the bottom line, is this, digital estate planning isn't just about protecting, your Facebook account, Bitcoin or airline miles, for federal employees as well. It's about making sure your spouse or heirs can access TSP funds, OPM retirement benefits and personal records without, unnecessary delays or legal battles. Planning ahead ensures your legacy is secure and your family is supported. So don't wait until it's too late. Just review your estate documents, update your digital inventory, and take advantage of the online tools available to you. By planning now, you'll make sure your benefits and your personal digital life are protected for, the people who matter most. So thank you for watching. If you'd like to dive deeper into topics like this, make sure you just subscribe to our channel and visit our website for more resources like who we are. And as you can see, our team on the screen there as well. You'll find our information in the description box below. Also on the screen here, you'll see our 2 QR codes. The first one takes you to our website to get more information on our firm, our process, and to schedule a no-cost retirement readiness consultation, where we'll learn more about your situation, goals, and needs, and share how our firm can help. And the second takes you directly to our YouTube channel, so you can subscribe and stay up to date with our latest content. So until next time, take care and stay informed.